There's a mistake that homeowners over 60 make every single day in America. Not because they are careless, not because they did not plan, because nobody sat them down and showed them what happens to their home and what it costs their family. When one document is missing, one title is wrong, or one transfer is done in the wrong order, the home they spent 30 years paying off, the home they raised their children in, the home they planned to leave behind as the most valuable thing they ever built, gone. Not to market forces, not to bad luck, but to a tax bill, a probate court, a Medicaid look-back, or a capital gains hit that nobody warned them was waiting. 5 mistakes. 5 specific decisions that homeowners over 60 make, or fail to make, that end up costing their families $20,000, $50,000, $75,000 or more. And most of them have no idea any of these mistakes exist until it is already too late to fix them. $20,000, $50,000. $75,000 handed to the IRS, to a probate court, or to a state Medicaid office on a home that was supposed to be the family's biggest inheritance. And the part that makes every one of these mistakes so expensive is that they do not announce themselves. They do not show up as a problem the day you make them. They show up years later, after you're gone, after the house is sold, after the title is already passed, when your family is sitting in a lawyer's office trying to understand a bill they never saw coming. Over a 20-year retirement, getting just one of these 5 mistakes wrong costs families more than most retirement tax bills combined. That is a house. That is your grandchildren's college fund. That is the legacy you spent your entire life building, quietly taken by a rule the IRS never explained and a document nobody told you to file. Today, I'm going to walk you through the 5 mistakes that homeowners over 60 make that end up costing their families the most, and exactly what each one costs in real dollars, not based on headlines, not based on what your neighbor told you at a dinner party, based on what the IRS, Medicaid, and probate courts actually do to your home when these 5 things go wrong in 2026. This video is for educational purposes only and is not tax, legal, or financial advice. Consult a qualified tax professional and estate planning attorney before making any decisions about your specific situation. My name is Kevin Retires. Every week I break down the tax rules, the financial traps, and the strategies that protect retirees from the things nobody else is explaining. If that sounds like something you need, hit the subscribe button right now and turn on notifications so you never miss a video. Let me start with the mistake that costs families the most money, because most people over 60 are making it right now without knowing it. Number 1, gifting the home to your children while you are alive. It looks generous. The IRS turns it into a tax bill. Every week, homeowners over 60 transfer their home to their children while they are still alive. They do it to avoid probate. They do it to protect the asset. They do it because someone told them it was the smart move. And in most cases, it is one of the most expensive mistakes they will ever make for their family. Here is why. When you gift your home to your children while you are alive, they inherit your original cost basis, what you paid for the home, not what it is worth today. If you paid $80,000 for your home 30 years ago and it is worth $500,000 today, your children's tax basis is $80,000. When they sell, they owe capital gains tax on the difference, $420,000 in gain. At the 15% long-term capital gains rate, that is $63,000 in federal tax alone, on a home you gave them for free. Now, compare that to what happens if you leave the home to your children through your estate instead of gifting it while you are alive. Under the stepped-up basis rule, your children inherit the home at its fair market value on the date of your death, $500,000. Their tax basis resets to $500,000. When they sell, their taxable gain is $0. Their capital gains tax bill is $0. The same home, the same children. A different decision, and a $63,000 difference in what the IRS collects. Most homeowners over 60 who gift their home to their children do it because they think they are protecting it. They're actually handing their children a tax bill the IRS never warns them about until the house is already sold. Number 2, keeping the wrong title on the home. 1 word in a document. Can send your family to probate court. The way your home is titled determines exactly what happens to it when you die. And most homeowners over 60 have never looked at their deed since the day they bought the house. That document, sitting in a drawer or filing cabinet, may be the most expensive piece of paper in your entire estate, and most people do not know what it says. If your home is titled in your name alone, it goes through probate when you die. Probate is the court process for transferring assets, and it is expensive, slow, and public. In most states, probate costs between 3 and 8% of the estate value. On a $500,000 home, that is $15,000 to $40,000 in legal fees and court costs paid by your family before they receive a single dollar of the inheritance, and it can take 6 months to 2 years to complete. If your home is titled in joint tenancy with right of survivorship, it passes automatically to the surviving co-owner without probate, clean and fast. But if both owners die at the same time, or if the surviving owner later wants to add a child, the title complications start immediately. The most protective option for most homeowners over 60 is a revocable living trust, where the home is titled in the trust's name and passes to your beneficiaries without probate, without court costs, and without delay. The trust does not change who lives in the home or how it is used. It simply ensures the transfer happens exactly the way you planned, without a lawyer, a judge, or a 6-month waiting period standing between your family and the home you built. A family that inherits a $500,000 home through probate in a high-cost state could pay $20,000 to $40,000 in fees that a properly structured trust would have eliminated completely. That is real money walking out the door on a document that most homeowners over 60 have never reviewed since the day they signed it. Number 3, not understanding the Medicaid look-back rule. Transferring the home too late can cost the family everything. Most people over 60 assume that if they need nursing home care, Medicaid will cover it. And in many cases, that is true. But Medicaid has a rule that catches most families completely off guard, and it is built specifically around the home. Medicaid reviews every financial transaction you made in the 5 years before you apply for long-term care benefits. That is the 5-year look-back period. If you transferred your home, gifted it to a child, sold it below market value, moved it into a trust, within those 5 years, Medicaid treats that transfer as a disqualifying event. You are penalized by the number of months of nursing home coverage Medicaid will not pay for, based on the value of the asset you transferred. A homeowner over 60 who gives a $300,000 home to their children and then needs nursing home care 2 years later, at an average cost of $9,000 a month, could face a penalty period of 33 months during which Medicaid pays nothing. That is $297,000 in nursing home costs the family has to cover out of pocket, on a home they already gave away. On a rule the IRS and Medicaid never explain until the application is already submitted. The 5-year look-back window means the time to plan around this rule is now, not when nursing home care is already needed. Most homeowners over 60 who understand this rule act on it immediately. Most who do not find out about it the hard way, when the penalty letter arrives and the window has already closed. Number 4, missing the capital gains exclusion. When selling the home. The IRS gives you $500,000 tax-free, but only if you qualify. When you sell your primary residence, the IRS allows you to exclude up to $250,000 in capital gains from taxes as a single filer, $500,000 for married couples filing jointly. This is one of the most valuable tax breaks in the entire tax code. And most homeowners over 60 assume they automatically qualify. Many of them are wrong. To claim the full exclusion, you must have owned the home and used it as your primary residence for at least 2 of the 5 years immediately before the sale. Both conditions must be true at the same time. If you moved out of the home more than 3 years before selling it, to move in with family, to go into assisted living, to rent a different property, the 2-year residency test fails. The exclusion disappears, and the entire gain becomes taxable. A homeowner over 60 with a home they bought for $100,000 and sold for $600,000 after moving out 3 years earlier owes capital gains tax on $500,000 of gain. At the 15% long-term rate, that is $75,000 in federal tax, on a home they lived in for 30 years. On an exclusion they thought they had, but lost because of a timing decision nobody explained to them. The exclusion does not expire, but the residency requirement is strict. And most homeowners over 60 who plan to sell their home, move in with family first, and then sell later, are quietly building a capital gains bill they did not know was coming. Number 5, never updating the deed, the will, or the beneficiary designations after a major life event. This is the mistake that is easiest to avoid and the one most people never get around to fixing. The deed on the house, the will, the beneficiary designations on every financial account attached to the home. Most homeowners over 60 set these up once, decades ago, and never looked at them again. And what was correct 30 years ago may be completely wrong today. An ex-spouse still listed as a joint owner on the deed, a deceased sibling still named as a beneficiary, a will that divides the estate evenly between 3 children, when one of them has already been given the house informally and the other 2 do not know it. A trust that was never funded because the home was never actually retitled into the trust's name. Every one of these situations creates a legal dispute when you are gone. A legal dispute means probate. Probate means court costs, attorney fees, and delays. Attorney fees in a contested estate can run $30,000, $50,000, $100,000, paid from the estate before your family receives anything. And here is the most common version of this mistake. A homeowner over 60 creates a revocable living trust, pays a lawyer to set it up correctly, and then never transfers the deed into the trust's name. The trust exists on paper. The home is still titled in their personal name. When they die, the home goes through probate anyway, because the document that was supposed to protect it was never connected to the asset it was meant to protect. The fix is simple. The cost of not fixing it is not. A deed review, a beneficiary audit, and a title update take a few hours and a few $100s. The probate process that replaces them takes 12 to 24 months and tens of thousands of dollars. Most homeowners over 60 know they need to do this. Most of them have not done it yet. Let me put a real number on all 5 of these mistakes together. Take a couple, both 68. They own a home worth $500,000 that they bought for $90,000 30 years ago. They have 3 adult children. They gifted the home to their oldest child 2 years ago, thinking it would avoid probate. The title was never updated to a trust. The will was last updated in 2009, and one of them is now beginning to need assisted living care. Mistake 1, the gift triggered a carryover basis. When the child sells, the taxable gain is $410,000. Capital gains tax at 15%, $61,500 the family did not expect to pay. Mistake 3, the gift happened 2 years ago. If the spouse needs Medicaid for nursing home care within the next 3 years, the 5-year look-back catches the transfer. Potential penalty period, more than 40 months of uncovered nursing home costs at $9,000 a month, $360,000. Mistake 5, the will from 2009 names a beneficiary who is now deceased. The estate goes to probate, court costs and attorney fees on a $500,000 estate. $20,000 to $35,000 paid before the family receives anything. Total cost of 5 mistakes on one home. Over $400,000 in tax, penalties, and legal fees on a home that was supposed to be the family's biggest inheritance, on the exact same house. Just different decisions made before it was too late to change them. Here is what changed in 2026 that makes all 5 of these mistakes more urgent right now than they have ever been. The federal estate and gift tax exemption is $15 million per individual in 2026. That means most families are not paying federal estate tax, but the capital gains trap in mistake 1, the Medicaid look-back in mistake 3, and the probate costs in mistake 5 have nothing to do with the estate tax exemption. They hit families at every income level, and they hit hardest when action was delayed. The SALT deduction cap jumped from $10,000 to $40,400 for 2026. If you're in a high property tax state and you're considering a trust or a deed transfer, the property tax deduction math has changed and you need to run the numbers again before you act. And the $6,000 senior bonus deduction for retirees 65 and older is brand new for 2025 through 2028. If you're selling your home this year and you qualify, that deduction reduces your adjusted gross income, which directly affects whether your capital gains stay at 0% or cross into the 15% bracket. Most homeowners over 60 who are selling this year have never been shown how these two numbers interact. The window does not stay open. Now you know the 5 mistakes that homeowners over 60 make that end up costing their families the most, and exactly what each one costs in real dollars. But here is what most people do not think about next. Protecting the home is only one part of the picture. You still need to make sure you are not handing the IRS extra money on the income that home generates every year. Watch my video on the 6 retirement tax traps waiting for you after age 65, because I break down every threshold, every deadline, and every rule that works in your favor if you know where to look. This is Kevin Retires. If this video helped you, hit the like button right now. It takes 1 second and it helps this video reach more homeowners over 60 who need to hear it. If you're not subscribed yet, hit subscribe and turn on the bell so you do not miss the next one. And if you know someone over 60 who owns a home and has never reviewed their deed or their will, send them this video. The difference between making these 5 decisions correctly and getting them wrong could be $400,000 or more for their family. Drop a comment right now. Do you own your home and are you over 60? Have you reviewed your deed and your will recently? I read every single one, and the most common situations become future videos.